Your Honor, we would like to set this matter for exam.
Further, paying my attention and looking at the defendant's jail calls before he was released and after he was arraigned, he made 50 calls to the victim from his PIN to her listed number after being arraigned. And that doesn't count the day that he was arraigned after he was arraigned. That only encompasses days exclusively after he was arraigned. He calls her 50 times. So I have concerns given that also at arraignments, the magistrate indicated his concerns that he will not follow court orders and that he would go back to contacting the victim as soon as he was released. And it seems that he didn't even do that prior to being released. He did it while he was still in custody. So I have concerns given now that he is out for safety. I also have concerns given the facts of this case in which his grandmother is the person who reported the crime after she awoke blood-curdling screams from the victim and felt she had to call 911 after hearing the victim being slapped. So I have concerns for safety given that he was contacting her excessively from jail.
When was he released?
I'm sorry, could you?
When was he released from jail?
I believe it was the 26th and he was arraigned on the 24th after being arrested on the 23rd. Could I attempt to respond, Your Honor?
Go ahead.
My response is primarily based on the facts of the case. This complaining witness stated she was not assaulted. The grandma did not witness any sort of assault. As the prosecutor told you, she said she heard something. So there's no witness that actually witnessed an assault. So then, Your Honor, the police say he's laying on a mattress with a blanket on him, which we would commonly call sleeping. The complaining witness tells the police he has a head injury from falling down, okay? So he's sleeping and has a head injury. The facts of the felony charge in Washtenaw County in 2025 is that he had to be told 3 times to turn around and 4 times to back up. And that's a felony. And now we want to revoke his bond, which is basically a due process violation because you take away his trial right. His trial will be in about 8 months.
Why am I taking away his trial right?
Because if he's incarcerated, then it's make a get out of jail plea. I mean, he's talked to.
It's not, counsel. And quite frankly, this court resents that you even make that argument that this court would be involved in violation of anybody's due process rights. He's given conditions. If he does not follow those conditions, he pays the consequence.
I agree. I just indicate to the court, I don't think the person that the condition is regarding wants that condition. She didn't want any of this. And then
there's a way in which that's taken care of, not by him continuously calling. He knows he's not supposed to be
I mean, Your Honor, he's 19 and it's Christmas. I just asked the court to give him a chance until we have a date on the 13th. I mean, if this witness says he's contacting her currently, you know, she comes to court on the 13th and tells the court there's a bond violation. I clearly don't have an argument to that, but if the court would let him stay out to the 13th and he's not going to contact.
I don't know what he's doing now. I mean, that's what part of the problem is. Part of the problem is that, and by the way, not only is your client entitled to due process, but the people are entitled to due process. Everyone is entitled to due process, and it is my job to make sure that it happens. If I believe for whatever reason that he may be interfering with the people's due process rights to fairly present their witnesses and have their witnesses present, then I'll take action, which I'm about to do now. Right now, his bond is revoked. Defendant is remanded. Thank you. Yes, and his phone privileges while in jail are revoked. Put that, can you?
Would the court only revoke as to the 2 persons with no contact orders?
I'm revoking his phone privileges.
Okay, thank you.
State your name.
Joseph Hafner Cantor.
All right, what are we doing?
Your Honor, we're asking for a preliminary examination at this time.
Discovery is complete.
Believe so, Your Honor.
People have their witnesses available the 13th. Preliminary examination in person, January 13th, 2026, 9 a.m. before me.
Where?
Bond continued. Thank you.
I think last time we were here was December the 4th.
Pardon?
Last time we were here was December the 4th. I have a violation dated December the 9th. Bond violation.
And we are in receipt of that, Your Honor. I did review it with my client.
You have a bond violation? I do. Behind that, I need these in the front.
So it does seem to indicate,
We were here last on what day?
I thought December the 4th.
Yes, I have December 4th. And I've got,
So it does appear that these tests were in the interim period between the last time we were here and this
Mr. Allen.
with positive alcohol blows on the silver link.
I've got a positive on December 8th. And then missed test really through the 9th, early into the morning. So the 8th was at 11:37 p.m. 0.07. And then 04, probably the same alcohol, maybe a little bit more, by 8 a.m. that morning. So some 8 hours later, he's still blowing numbers. Except that then a little bit later, it popped up and then went down. So it looked like he was continuing to drink. Then the worst thing happened. They spoke with him, and he said he didn't have any alcohol.
And Your Honor, I believe Mr. Hafner Cantor is changing his position on that now.
Really?
He
Yes,
did
sir.
appear on the same day that this violation report was submitted. He appeared before Judge Frushauer to be arraigned on a misdemeanor OWI. The misdemeanor OWI date of the alleged offense predates this case. I think it was just authorized later due to lab results. But nevertheless, he appeared for arraignment knowing that this violation was there, and it was addressed at that time by Judge Frushauer, who had him taken into custody with a $5,000 10% bond. I think the condition of that bond,
On this case?
he was taken into custody at the time of his arraignment.
You're saying two different things to me. Her taking him into custody at the time of the arraignment is one thing. If she's taking him into custody on this case, that's a different thing and not something that I see in this file.
And you're correct. What happened was, after the court considered this bond violation and received the report from his tether agent, bond was set in the amount of $5,000, 10%, with the condition that he be fitted with a SCRAM tether before that bond shifts to a personal bond. So he was fitted with a SCRAM tether. He remains on that SCRAM tether since December 9th, and I don't believe he's had any violations. Mr. Hafner Cantor is employed and has stable housing with his employer in Saline. Your Honor, I would ask the court to consider continuing his bond, because I think him being on a SCRAM tether is kind of the constant reminder he needs not to drink. I will note the present offense. I don't believe there are any alcohol related allegations, but of course he does have a misdemeanor OWI, and he admits he has a drinking problem.
Yeah, but this response from the people.
The people are glad that he has now a SCRAM order on the OWI case that's pending before Judge Frushauer. However, it's still a violation in this case to have been drinking. I'm not sure. I know the court generally will issue warrants pretty quickly when these things sort of come through. I'm not quite sure what happened here, but no matter what, it does.
Is there a warrant issued on this one?
It does appear to the people that alcohol is a significant problem for the defendant. It appears that SilverLink is not working. So I would ask that the court, at the minimum, order the SCRAM in this case as well.
Did he take the ETG?
Doesn't look like it from this report.
I did not give you one.
So there was a warrant issued on this one, okay.
Okay.
Is it still out?
For Mr. Haffner?
Yeah.
Okay.
No, I do not see that a warrant.
Oh, you do not see that
I
one.
do not see, no. So the report says, I advised him to report to community corrections for an ETG urine test by end of the day. This is on 12/9. He said he had court and only had transportation there, doesn't have any money to take the urine test. I advised him a violation would be sent, and I was affording him the opportunity to take the ETG test to provide results with my report if in fact he was not drinking. And I just confirmed with Mr. Cook. Mr. Cook informs me that the defendant had a positive BAC coming into court. I'm not sure if that's related to this violation report or if it was actually going to court, but it does all appear to be on the same date, that December the 9th sort of time frame.
So when did he appear before Judge Freshour?
It looks like December the 9th,
That's correct.
What time?
9-ish in the morning.
So she may or may not have been aware then,
She was aware, she remanded him, and
but was she aware that he was intoxicated?
Mr. Cook's note indicates, and his communication to me indicates that he had a positive BAC coming into court. I'm assuming that means he was blowing numbers at court. And I know that community corrections was there.
Okay, I'm pretty much done. I mean, you drink coming into court, you drink in violation of my bond. I saw you 4 days beforehand. And no,
May I speak?
we don't do that. Say whatever you want.
Your Honor, I think what Mr. Hafner wants the court to consider is that since this string of events leading up to the court date on December 9th, I think he has pivoted and changed his position from denying
So let
his
me get this
problem.
right. You're telling me that all of a sudden everything has changed. On December 8th, he's drinking. He's drinking well into the morning on December 8th. He has to appear in court, can't stop drinking, and then ends up at court that day. He talks to community corrections, I think, on that same day and just is absolutely lying to them. And somehow between now and that date, he has made a certain epiphany has occurred and he's made some miraculous transformation. Is that what you're telling me?
Your Honor, I understand the court's concern. Mr. Hafner Cantor, when were you released from the Washtenaw County jail? Was it the following day or this?
I was there for a week. I think I was released on the 19th or the 18th.
So, Your Honor, he's strung together 10 days on a SCRAM tether with no issues whatsoever. And I think that's what he wants the court to consider in reassessing bond here. I would ask the court to continue his bond based on the fact that he's come into compliance since being placed on the SCRAM tether.
He's in violation on my case, goes to another court drunk.
And Your Honor, I would like to correct my record I made to make sure that it's accurate. Mr. Cook has let me know that he doesn't know if the defendant was individually touched at the court, but because he had the 0.04 30 minutes before the judge saw him, Mr. Cook's note was that he was drinking. So I apologize if that was confusing at all. I just want to make sure.
So he wasn't breathalyzed at court.
Now that Mr. Cook's aware.
Where
But
it's because it was 30 minutes before, there was an assumption that, which is a good assumption.
it's pretty fair, yeah.
Anything else?
Your Honor, I know Mr. Hafner Cantor's been in constant contact with his community corrections agent, and I know that his 3-year-old daughter, who he takes care of, is his biggest concern. I think he was dealing with some stress regarding a custody situation with respect to his daughter, and
He's violated my bond. And then absolute disrespect showed up at another court, still under the influence of his drinking event that violates his bond in this case. and he's appearing at that time on an OWI, and he's not in any treatment. Anything else?
Nothing from the view.
Nothing further, Your Honor.
Bond revoked, defendants remanded.
Your Honor,
Yeah.
and
The 13th is.
And with respect to that date, he does appear in district court on that same date. I'm not sure if the court wants to move it or if the jail would be able to accommodate that
District court where?
for the OWI case.
Well, he wouldn't name until much later.
Which judge is the exam?
Me.
You.
Thank you, Your Honor.